everyone. Welcome to the Standing Committee on Transport and Public Works. My name is Ricardo Mackenzie. I'm a chairperson of this committee. I'm going to ask the members of the committee just to introduce themselves and for anybody to note if there's any apologies. Members, can you introduce yourself for the record, please?
Good afternoon, Chair and officials and members on the platform. My name is Derek America. I'm the member of the committee.
Good afternoon, Chair. Andrikus van der Westhuizen, also a member of the committee.
I did see Member Heron here early on.
I am here, Chair.
Thank you. Member Brad Heron is here. Seems to be no other member on the platform. Thank you. Minister Mitchell, I see you here and your team. Can you introduce yourself, please?
Thank you, Chair. Good afternoon, members. Members of the department, HOD. Dalen Mitchell, Minister of Transport and Public Works.
Thank you, HOD Gooch and your team. Thank you.
Thank you very much, Chair. Good afternoon to you and to the members of the committee and the other people also involved on the call. Jackie Gooch, I'm the Head of Department of Transport and Public Works. And if you don't mind, Chair, I'll ask my team just to introduce themselves within the alphabetical order. It's probably the easiest that we see on the team's profile, if you don't mind. And we do also have with us as well some external specialists that have assisted us in the development of the legislation. So if you would also allow them to introduce themselves.
Yes, please. I'll get their names.
Thank you, Chair. So perhaps it's then to start, if you don't mind, with through Carl.
Thank you, HOD. Good afternoon to you and to the Chair and members of the committee. Thank you for having us this afternoon. I'm Carl October. I'm the Chief Director Roads Planning within the Department of Transport and Public Works. Thank you.
Good afternoon, members. My name is Len Fury. I'm Head of Roads in the province.
Skulk.
Good afternoon. I'm Scott Carstens in Road Use Management under Carl October in the Department of Transport.
Thank you, Skulk. We also have Gerrit.
Good afternoon, Honourable Chairperson, Honourable Members. Gerrit van Skalkwijk, Acting Head of Strategy, Transport and Public Works.
And through you, Chair, if I could ask Tony Abramson to introduce himself. Thank you.
Hi, good afternoon, Tony Abramson. Good afternoon, a pleasure to be here at the meeting. I've been assisting the department on and advising them on preparing this legislation for some time.
Thank you, Chair. That's all the team that I can pick up. I hope I haven't missed any of the DTPW team members, but I don't think so. Thank you, Chair.
Okay. Thank you. Just for my colleagues, I got Candace Morris here with us. I see Abongile is here. Our legal advisor, Mr. Marsdorp, is here. Mr. Johan Vermeulen, and obviously my right-hand man, Mr. Johannes Kutsi, is also on this committee with us, and Namfundo is also one of my colleagues joining us that I can see right now. If anybody that you missed, you please raise your hand or introduce yourself before we continue.
Good afternoon, Chair. It's Amanda Tall from Legal Services. I've been supporting the department on the bill. Thank you.
Thank you, Amanda. Amanda, you're from the Department of the Premier, right?
Correct. My apologies. Yes. The Department of the Premier.
Right, I remember your name. Thank you. You can go ahead, Mr. Tembaletu.
Yeah, good morning, Chair. My name is Temba. I'm the Manager PEO. Thank you.
Thank you. Good to see you here. I see there's no other hands, colleagues, so we'll start with the meeting. Thank you very much for introducing yourself. Just for basic record purposes, please, if you speak, switch on your mic and your camera. And once you finish speaking, please switch off your mic and your camera. Just for the record, all documents submitted to this committee are deemed as public documents unless otherwise agreed before this committee. So anything that is submitted to this committee is by now onwards is considered public documents. And also that this meeting is broadcast live via YouTube, and any interested party can have access to any of our recordings. Also for technical assistance or PowerPoint or otherwise, we have IT consultant also on this call. If you can just message us and we'll provide assistance where needed. In terms of Section 10 of the Directives of the ATC, issued on the 27th of April, all the standing rules apply. That is also applicable in our physical standing meetings. In instances where the directives are not clear or do not cover a particular eventuality in respect of the sittings of Parliament or any of the meetings, in terms of the standing rule will apply as far as it reasonably possible or practically possible. In instances where they not apply, the ruling of the presiding officer, which is myself, is final. There's no interpreting services available, and we'd appreciate it if all the communications here onwards is in English. That will be the medium of this meeting. We're going to start just the Minister Dalen Mitchell. I know that he was attending or going to attend another meeting after the introduction. I think he's in Beaufort West attending public meetings there, and he will do the introductions and depart us by the HOD, and the department is here to assist us with technicalities on the bill. And once we've asked questions for clarifications, members, as you know, we are going to take this bill to the public. And as in the past, we're going to see this presentation probably 10 times over the next few weeks. We've done it before in public hearings because unfortunately that is our role, or fortunately that is our role, to take this bill to the public. So Mrs. Gooch, Minister Mitchell, I'll hand over to you to take us through this bill.
All right, thank you very much, Chairperson, members. Just for the record, I'm not in Beaufort West, I'm in Cape Town.
Oh, you're back, okay.
But I have another engagement, but I will leave after the presentation. Chair, I just want to thank the committee for this opportunity to present this very important piece of legislation, because this is a critical step in finalizing this legislation that is actually going to replace two pre-democracy pieces of legislation, including the Roads Ordinance of 1976. This transport infrastructure bill, Chair, fills the gap in the the current transport legislation, including the National Land Transport Act and the National Road Traffic Act. But the HOD and the department will take the committee through step by step through the technical aspects of the bill. Thank you, Chair. That's all from my side, and I want to say that we obviously want to use this opportunity to iron out all questions that the committee will have before you embark on the public participation process. Thank you, Chair.
Chair, if I may, thank you very much to you and to the members of the committee and to Minister Mitchell for his opening comments. As he's mentioned, this particular piece of legislation for us is vitally important and something that is really kind of sets the base for the work that our roads infrastructure team do. We will this afternoon have the presentation made by Carl October and supported by Tony Abramson. And I would also like to request that as the committee is hearing the presentation, and as you've mentioned, Chair, you will land up probably hearing it, I suppose, many times into the future as you go through a public process. If there are any elements that you would like us to focus on or to be able to assist for the public process that you believe are important to highlight, that we would also dearly appreciate any feedback that you may have in that regard. So, Chair, not to hold you up with any further introductory comments from my side, I do believe that we've tried to keep the presentation as short as possible and make it as clear as we can, but certainly then I will ask, with your permission, Carl October to start and to take us through between him and Tony Abramson. Thank you very much, Chair.
Thank you. Can I just make one comment quickly? I've seen the comments that have already been submitted by Drakenstein in the city of Cape Town. And I'd like, as we go forward, and some other members might later to also want to speak to that, because they both seem to talk to similar issues, if one can address that going forward, if not in this presentation, perhaps in the next one. Thank you.
Thank you, Chair. And I suppose if they were submitted through to the Standing Committee, in terms of your process, it would be great if we
will
could
send it through to
get
you.
copies,
Yes.
so that we could then facilitate those comments. Thank you.
Yeah, thank you. You can continue.
Thank you, Chair. Thank you, HOD. Good afternoon to everybody, committees of the Chair of the committee, members of the committee, as well as to everybody else present. Thank you. Thank you for this opportunity again, and I'm glad the meeting is being recorded. It will help us also with comments coming through and discussions coming through in this meeting. So thanks for that, Chair. The bill is a product of many years of work, and we are proud, Chair, to have achieved this with the involvement of many individuals, officials in the department, municipalities and other provincial departments working cooperatively together. I will take you through the initial slides dealing with the background and process, and I'll ask Mr. Tony Abramson to take over when we deal with the content of the bill. He's been assisting the department for some time in this process and has a background in engineering and experience in making legislation. I think it's appropriate to set the scene by giving us some brief statistics about the road infrastructure, which the department is the custodian of. So before I get into all the slides, the province is the owner of some 32,000 kilometers of provincial roads. There's around 1 million vehicles per day on these roads, and they work out to about 30 million vehicle kilometers per day. There's some 6,600 of these roads that are major surface roads, meaning trunk roads and main roads, whilst around 26,000 are unsurfaced roads, serving local communities. Like these roads are divisional roads and minor roads mainly. The network value, or the asset replacement value, currently is around 65 billion rand. There are, in addition to the provincial roads, a further 1,000 kilometers of municipal main roads within the urban parts of the Western Cape. Cape Town, CBD, or the metropolitan boundary, within the boundary shares about 750 kilometers of such roads, and the rest about 250 in the rest of our province. These roads are declared under the current ordinance. As the MSC rightfully said, it's an old piece of legislation but still in action. They carry high volumes of provincial traffic and are therefore of a provincial significance. These are potentially roads of joint significance, which is a new categorization provided for in the bill. Now, these roads of joint significance, which I'll further in the meeting, and as Tony will also eventually be speaking, we'll call them RJSs as we go along, roads of joint significance. They are owned by municipalities. The province has a strong interest in administering them, and it provides the municipalities with financial assistance under the road subsidy provisions within the bill. The current ordinance also has a similar provision in terms of the subsidy. So getting to the slide on the screen in bullet 1, as shown in the outline, we will indicate where the bill is lodged within a suite of transport-related legislation and what it does not provide for. Secondly, we cover the process with which your committee is now engaged with until the bill is assented to. And then thirdly, we'll provide some background into how the department has been engaged over several years to reach this point. I'll hand over to Tony once I'm done with the background to take you through some slides of important clauses covered in the bill. And at that stage, you may want to flip open your copy of the bill, as we will be referring to some of these pertinent clauses. Bullet 5, there'll be a couple of slides to inform you of the supporting legislation which the department is developing, and then finally some key implications on the province for making these bills. This bill, sorry. With respect to context, I'd like to make it clear where this legislation fits into the whole transport sphere. Firstly, the bill, as it stands, is essentially for the administration of Western Cape provincial infrastructure, mainly roads in the province and not transport operations. The National Land Transport Act, or the NLTA, is for transport planning and also for transport operations. It is designed to provide for the legislative needs of all spheres of government, whilst Law 8, the Road Transport Act, regulates provincial taxi associations. The NRTA, the National Road Transport Act, is also a national act. It's for the use of all three spheres of government for the administration of traffic regulation, operations, and safety. Not shown on the slide are other important pieces of legislation. Firstly, the Legal Succession Act of the of South Africa, Transport Services, called SATS, Act 9 of 1989, and its amendments. This is a national act which administers transport and port net. Here, PRASA is established separate from Transnet. The Metro Rail operated passenger rail system is owned by PRASA, which is the rail association. And then secondly, the National Railway Safety Regulator Act of 2002 and the Transport Ministry, which regulates safety standards and practices on rail services. And the process, as the committee is familiar with the steps to enact legislation, I'll merely focus here on a few key dates as indicated on the slide. The bill was introduced into legislature on the 13th of April. It was then advertised on the 12th of July. We received adverts, as Chair alluded to, and thank you again for sending us those comments. Those comments came through on the 18th of August at the closure of the comment period. And then today we're dealing with a bill in front of with the committee. The Standing Committee will inform us in due course on its consultation program and how we can provide support. There were only two sets of comments to date which we received on the 18th. One was from Drakenstein Municipality and the other from City of Cape Town Municipality. In response to the invitation, publication of the Bill B5 2021 on the 20th of July. The comments acknowledged previous rounds of the consultation. And firstly, in the case of Drakenstein, the municipality is requesting that the subsidy for roads of joint significance should be fully subsidized by the province. In the case of the City of Cape Town, the city is requesting that applications for permissions be subject to a maximum turnaround of 60 days. The role of province on the cities also wanting clarity on the role of province on the permission to display advertisements. on provincial roads and roads of joint significance. Chair and members, we will analyze the comments in detail and submit our responses to the Standing Committee shortly. We'll deal with the work on the regulations later on in this presentation. However, it will be optimal to commence the Act and the regulations simultaneously and in full. In terms of background, leading up to the bill, the province has used the Road Ordinance and Act 21 of 1990 for many decades to administer roads and transport infrastructure. Work started on the replacement of legislation several years ago, which led to the Premier assenting to Act 1 of 2013 at that time. However, there were barriers to implementation of Act 21 of 13. Act 1 of 2013, forgive me, it's Act 1 of 2013, could not commence as the Act relied on the readiness of these regulations. In Bullet 2, the regulations were being done in collaboration with legal services. And pursuant to these discussions, the following amendments were brought in to Act 1 of 2013. Firstly, Sub-Bullet 1, provisions for outdoor advertising were in conflict with the Constitution, as municipalities have the competency to approve applications. Secondly, the installation of service infrastructure. Many fiber optic cables are incorporated in our road reserves. So that bullet specifically refers to fiber optic cables. These are required. There were regulations required to protect road authorities and to uphold standards. Various other technical amendments in terms of, for instance, land use applications and draft standard bylaws were also needed. And then Bullet 3, to do the above, the draft amendment bill was then established in 2017 together with draft regulations, which were published for comment. The department was advised to seek external advice from Council at that stage. In addition to resolving issues of advertising, further provisions were recommended. Firstly, Sub-Bullet 1, rules for the joint administration of RJSs with due regard for the constitutional functions of municipalities to administer municipal roads, as found in Part B, Section or Schedule 5 of the Constitution. In Sub-Bullet 2, criteria for determining of the road should be how it should be classified as a provincial road, a municipal road, or an RJS. Since RJSs are essentially part of the provincial network, they are deemed also to have the function of provincial roads and traffic, which falls under Part A, Schedule 5 of the Constitution. Various sections also provide for the department to assist municipalities with functions on RJSs. In Bullet 3, due to these amendments, the department was advised to develop a new bill. Otherwise, users would have to cross-reference a complex set of amendments in an amendment act read together with Act 1 of 2013. However, the work was not wasted, as the 2017 Amendment Bill and further provisions were worked into the current Transport Infrastructure Bill. Chair, we found it necessary to provide you with this lead up to the current bill, as it sketches the wide consultation that was necessary and required. The latest rounds of consultation preceding to the introduction of this bill included, firstly, the approval by Cabinet for publicising the bill for comment. That was November 2019. And then secondly, the draft bill was publicised for public comment in January. And then consultations were held with key stakeholders. This happened over a 3-month period. assisted with the South African Local Government Association, SALGA. There was considerable interest with many comments received. This was really great from the municipalities, from Department of Economic Affairs, Development and Tourism, from Environmental Affairs, and from Provincial Treasury. And I think we had 2 rounds with Treasury. The department considered all comments and developed a response table and associated amendments to the draft bill. In bullet 1, we see that the department was then initiated further bilateral consultations with all listed entities to address their comments and concerns. And those are the listed entities and dates there. Resulting from these consultations, several key amendments were made. These, as well as all comments received in the process, are recorded in a comprehensive comment and response table, which is on record and available on request. The department at this stage would like to thank the dedicated officials of the listed provincial departments and municipalities for their invaluable contributions and their time spent in compiling comments and discussing them with us in these meetings. We really appreciate the commitment towards ensuring a bill that is sound and workable for all. This final slide on background provides a list of issues resulting in final amendments during the consultations mentioned. We had to introduce clause 70, which speaks about exemptions from the requirements for RJSs in the bill. And then we introduced clause 61 to do with consultations on standards and guidelines made by our HOD. Clause 65, which provides for municipalities and the department to integrate approvals. And then clause 39, there's an important section on land use changes that impact our roads, requiring approval from the HOD without subverting a municipality's function over land use control. And then finally, there were some technical changes. Chair, at this stage, I would like to hand over to Tony to take us through the content of the bill and some supporting legislation, like the regulations and draft advertising regulations, and also the implications of the bill. Thank you, Chair. At this stage, if there are any questions, or it's up to you, Chair. Thank you.
Thank you, Mr. Koper. We'll get the rest of the presentation, then we'll leave the questions afterwards. Thank you.
Hi, good afternoon again. It's my pleasure to guide you through the more detailed aims, objectives, and content of the bill. I'm afraid it's not going to be short, but I'll try and keep it as quick and clean as possible. As Carl says, I've been involved for quite a long time, and we've certainly all travelled a long way to get to this point. So we're very pleased to be here and see the bill, go through this process. Just dealing with bullet 1, I think it's been mentioned before, the ordinance and the advertising of on Roads and Ribbon Development Act are the two pieces of, or main pieces of legislation administering roads, and these two will be repealed and replaced by the bill. The ordinance and the advertising of Roads and Ribbon Development Act also are used to administer what is called municipal main roads. We'll come to what that actually means. And those become roads of joint significance under the bill. Bullet 2 recognises the importance of transport infrastructure other than roads. The department decided at the outset of making this legislation, this is goes quite a long way back, so that the bill not only provides for administration of the roads, the provincial and roads of joint significance, but also allows for the declaration of public transport-related infrastructure, for example, passenger rail and bus rapid transit. And in fact, it's also conceivable that the province could declare a freight rail system. And of course, as Carl mentioned earlier, this would be quite independent of the current rail systems which National Sphere administers, and that is Transnet and PRASA. So this is no attempt to take over or to administer those systems under this bill. It's not structured that way. It is new legislation. This is the one reason why it's necessary, that will be consistent with the Constitution, and in some very basic ways, for example, the relationship between the province and municipalities is aligned better in this bill than was obviously in the ordinance, which dates back to 1978 and 1940 respectively. Carl, could you just advance onto this one? Yeah, thank you. So this first slide just lists the chapter headings. And the next slide goes from 7 through to 12, because there are 12 chapters altogether in the bill. And within these chapters, there are 74 clauses. We've not attempted to provide slides for all of these clauses, but I will take you through some of their more important ones, leaving out those ones that are not key for today. It may be of assistance, or it may help in going through this that you have your copy, if you have one, of the bill before you, and then you'd be able to follow it more closely. At least if you had the contents page of the bill, you'd see how these sections fit in. So I'll take you first of all, Chapter 1, Introductory Provisions. After the definitions, which are Clause 1, Clause 2 then deals with the responsibilities of province and municipalities. And what Clause 2 provides for is it makes the minister and the HOD responsible for undertaking financing, planning, design, declaration, construction, all of these things that comprise the administration of transport infrastructure in the province. In other words, those parts of the infrastructure that belong to the province. The second part of it is that it then states that the municipality must do same functions, but these must be undertaken for municipal roads and roads of joint significance in their areas of jurisdiction. Clause 3, we're still under chapter 1. Clause 3 requires that the minister must ensure that key technical functions are performed only under the responsibility and due diligence of suitably qualified professional persons. It also, if you read the clause carefully, you'll see that it requires that there are such people who are embedded within the department who are able to supervise technical work on the infrastructure. Clause 4 deals with title to land for transport infrastructure. That's what the heading says, and it's essentially mainly due to it covers the acquisition and disposal of land necessary for transport infrastructure. I'll move on to Chapter 2, which is entitled, as you see on the slide, Classification and Categorization of Roads and the Declaration of Roads of Joint Significance. Clause 5 deals with classification. What has been introduced is a classification system, and one must just distinguish between the classification of the roads, the categorization of the roads. Classification is meant to identify who the road authority is, or the owner of the road. So therefore, when applied to the roads, the classification would separate them into provincial roads, municipal roads, and roads of joint significance. So it's able to, the Act enables one to be able to determine this classification. There are also broad criteria provided for in Clause 5 that, that allow one to be able to then determine the classification. Clause 6 provides for the declaration or withdrawal of roads of joint significance by the Minister. We'll move on to Chapter 3, for deeming provisions and regulation of municipal roads. This is quite an important chapter, or quite an important chapter, yes, and consists of clauses 8 through to 10, where 8 deals with deeming provisions, essentially that roads that were previously declared under the ordinance back in the past, once the Act commences, that these roads will be transferred and fall under the Act under the same conditions under which they currently exist under the ordinance. All municipal main roads will then become roads of joint significance. Then we get Clause 9. Clause 9 is there meant to assist municipalities with the regulation of their municipal roads and roads of joint significance. It provides for the system of legislation which ought to be in place for municipalities to administer municipal roads and roads of joint significance. And this will give effect to the very sort of brief description of their function, which is given in the Constitution. It's if you read Part B, Schedule 5, you'll find municipalities have the competency for administering municipal roads, but there's nothing further to tell you what they're supposed to do. And so this Section 9 then does that. As we said earlier, it requires that they must regulate the financing, planning, design, and all those things to administer the municipal roads and roads of joint significance. And you remember, of course, that roads of joint significance have a dual interest of both the province and the municipality. So when a municipality makes a bylaw which regulates roads of joint significance, then they must consult with the minister in making this bylaw. Moving on to Clause 10, and we're still here sitting in Chapter 3. It's called Joint Planning, Management and Control of Roads of Joint Significance by the Province and Municipalities. The first part is about transport planning functions. So the municipalities are then required under this section to undertake various planning activities. For example, the preparation of arterial management plans, and determine other attributes of roads that affect the access management of these roads. And then the second point is that that activities that the municipality wishes to undertake on their roads of joint significance must be firstly approved by the head of department. So they have to agree on the viability and the technical details of these activities before they commence. So that is quite important in this clause. There's also this other question about dual approvals. When persons or other organizations apply for permission to do something that affects a road of joint significance, for example, if they want to build an access off a road of joint significance into an adjacent property, then the municipality must consider that application and approve it or not approve it. But in addition to them, the head of department must also provide the permission for that work to be for that permission to be granted. Then the last point that I want to mention under here is that that this is to do with the complex decision-making procedures which are required. That I've spoken about the need for dual approvals by the municipality and the province for these permissions. Sometimes, there are other legal requirements that come into the picture as well. For example, requirements of the National Environmental Management Act. And so it's quite a complex process to get these approvals through, and very frustrating for the applicant sometimes. So there's provision here for integrating these procedures in this decision-making process here. So I'd like to move on to chapter 4. This is about what is called the joint assessment process and road transfer agreements. It includes two clauses. There's clause 11 and 12. 11 is entitled the assessment of previously declared roads. And what is envisaged is that quite soon after the Act commences, this joint assessment process should be undertaken in respect of existing roads of joint significance and provincial roads, which must be undertaken by the Minister in cooperation with the HOD and the relevant municipalities. And so we're talking about the something like 32,000 kilometers that Carl mentioned at the beginning of declared provincial roads, and the other 1,000 kilometers of municipal main roads, which become roads of joint significance on commencement of the Act. So all of these roads must be reviewed in this joint assessment process to determine the appropriate classification of the road as a provincial road, road of joint significance, or municipal road, and then also the appropriate categorization, or whether the road should be closed, or what the fate ought to be, or the outcome ought to be. And this process is arrived at by consultation between the province and the municipalities. And as you'd imagine, there could be disagreements taking place in this process. So there are deadlock breaking mechanisms built into clause 10 to make sure that these matters don't drag on and on. Public participation is also obviously required in the process. The culmination of the joint assessment process would be the conclusion of bilateral agreements between each municipality and the province regarding decisions that have been arrived at. So it sets out the principle of what must happen next. And then clause 12 provides for road transfer agreements, because there may be transfer of ownership from the province to municipalities, or from the municipality to the province of certain roads. And the next step would then be to implement that joint assessment agreement by a process of transferring the infrastructure through a series of road transfer agreements. And then that would be the mechanism for getting the transfer of these assets done. I'll move on to chapter 5 now. It then deals with railway lines. It's actually a basket of things. It's railway lines, public transport roads, and then it deals with reserve widths, ancillary infrastructure, and building lines and building restriction areas. It's kind of a catch-all chapter, not all of which is related to each other. But I'll take you through a few of the main clauses. Clause 13 provides for the categorization of railway lines. So the category can be declared as a heavy rail line or a light rail line. And by the way, unlike the roads of joint significance, these public transport infrastructure, or I know I said it could be extended to freight railways, but the railway lines would only belong to the province, and there's no provision made within this legislation for a municipality to declare its own railway line, as an equivalent. They would have to have their own bylaws in order to do that if they wanted to. And of course, as I said earlier, PRASA and SATS would remain under national administration. Clause 15 talks about the reserve widths of roads and railway lines. The bill provides standard minimum reserve widths of roads and railway lines, but on declaration of these roads or at any other stage, they can be varied in accordance with what is more appropriate. Clause 16 talks about categorization and reserves of ancillary transport infrastructure, and it defines the various types of ancillary transport infrastructure that exists. There's a long list of them. And for example, a parking area or a rest area can be declared as ancillary transport infrastructure. Building lines and building restriction areas are carried over from the previous legislation. We continue to have a building line of 5 meters outside of a road reserve or outside of a transport infrastructure boundary. And this is in urban and non-urban areas. And the bill also allows the minister to declare building restriction areas in rural areas, as does the Advertising on Roads and Urban Development Act. Chapter 6 is on planning and declaration. This is a chapter or a provision that didn't really exist in the ordinance, but what it tries to do is sets out some rules for how planning should be undertaken. The first part deals with transport system planning. It's somewhat related to the National Land Transport Act. It gives some transport system planning requirements that the province must attend to. For example, the HOD must prepare arterial management plans for provincial roads, and there are some other functions there under transport system planning. Clause 19 is about records of transport infrastructure and roads of joint significance. This is a list and comprehensive database of transport infrastructure in the province, which must be put together for provincial roads and roads of joint significance. Some of this information, a lot of this information already exists, but it will need to be supplemented and probably reorganized in some way. So it gives information, for example, about the declaration of the road and where it is located, and attributes like how wide is it, and what is the surface made of, and what traffic volume. There's a massive long list you can imagine that would fall into this database. But it's very important for the province to have such information in order to administer it properly. Then we go to clause 20, which is called a project planning process. This is planning in advance of implementing individual projects. So it's got to be undertaken before the declaration of a provincial road, or before the relocation or alteration of closure of such infrastructure, and before the withdrawal of a declaration of the classification of road of joint significance. So these all require the planning process. What it has there as requirements are set out in the bill, and the HOD must also ensure that necessary steps are undertaken to comply with other applicable legislation. For example, I mentioned earlier the National Environmental Management Act and other legislation. 22, clause 22, once the planning is complete, 22 is about declaration, and on conclusion of the planning and the public participation and the decision to go ahead, there then must be a declaration in the Provincial Gazette on that conclusion. I'll go to the next slide. This is the second half. hopefully we can get through this quickly. Chapter 7. This is to do with procedures on closure of transport infrastructure and consists of clauses 23 to 27. It deals with applications for closure by members of the public and so on, or relocation or alteration of transport infrastructure. It also deals with a temporary or permanent closure of a provincial road, and it deals also with closure and procedures for closure in cases of emergency. If it's not an emergency, normally there's an application process and public participation process before you can simply close something. Chapter 8, very important, is on financing and subsidy. This chapter, consisting of clauses 28 to 31, is mostly about subsidy and financial assistance to municipalities. Clause 28, which is road subsidy arrangements, this allows the department to pay a subsidy to a municipality for helping it administer its road of joint significance. Note that the bill doesn't provide for for subsidy to other types of roads that the municipality may own, like municipal streets, or municipal roads, which are local roads and not declared under the Act. It's only for this particular animal roads of joint significance. Clause 29 deals with the rent, sale, and other income from land acquired with subsidy under the ordinance. What this is about is that where a municipality concludes a lease or a sale or some other agreement relating to land which they originally received as subsidy money or grant money from the province, if they sell that land or lease it or whatever, they must pay the net income received in proportion to the subsidy contribution. There are also provisions here which allow the head of the department to grant the municipality to use that money for transport projects or earmarked projects which are transport related. 31, clause 31, which is about regulations on road subsidy, provides the minister to make regulations on the payment of subsidies. I must just say that you will find when you read the bill that the provisions on subsidy are quite short, and that is because 85 or 90% of the legislation will reside in the regulations. So there's a huge amount of additional legislation that you've not really seen unless you ever read the 27 Amendment bill, which was accompanied by draft regulations at that point. Chapter 9 is the regulation of advertisements. This is one of the tricky ones. Clause 32 prohibits the display of adverts within a specific distance of provincial roads and roads of joint significance without the permission of the HOD. But when the HOD considers the impact of these advertisements, he or she may only concern himself or herself with the road traffic safety and the operation of traffic of provincial traffic. So the province is not able to really comment on the immediacy or the decency or other things which are not transport related implications. That is for the municipality to determine and to decide on. Clause 34 sets out the requirements for a municipality to regulate the display of advertisements on or above or visible from a road. It essentially says that the municipality must set up a system for them to be able to properly respond to applications for advertisements, and it's really pointing at the need for bylaws to be made and which are effective for this purpose. I'm moving on to chapter 10, which is a big chapter. It's on the management and control of transport infrastructure roads of joint significance and adjacent land. It runs from clause 36 to 47. There are 11 clauses. The first one I just want to cover is 37, which is to do with access to and exit from provincial roads and roads of joint significance. And what is required is that people applying for such access must get permission from the HOD on whether this access is going to be permitted. I want to move to clause 39, which is also a rather difficult one. We found it very difficult to deal with and had a lot of discussion with DEDP on this matter, but hopefully we got it right in the end, that we don't, we tread the careful line between the province's authority and the municipality's authority over land use matters. So it's called restrictions and changes in land use. A person who's applying to a municipality for approval of a development involving a change or intensification of land use or subsequent or subdivisions which are adjacent to provincial roads and roads of joint significance. That's what it's intended to. They must apply for it to, and the head of department must consider the application in relation to the impact on provincial traffic and transport operations. Obviously, the municipality has got other matters which they consider when they apply their minds. It's also necessary to obtain the prior approval of the HOD. I've said that, relating to the impact of provincial traffic, and that's the HOD's sole sort of space in which to make that decision. Then there's also sections which I'm not going to deal with in detail. Section 42, 43, 44 about fences and gates and cattle grids and things. So these things, the bill says the erection of the fences must be can be by the HOD, and there's a prohibition for other people to erect these fences and gates and so on without the permission of the HOD. I'll say no more about that. I think these are fairly routine, road management related issues. Clause 45 deals with mining operations on or under transport infrastructure and roads of joint significance. It prohibits mining operations without the permission of the HOD. Clause 46 prohibits trading in or within a building line or building restriction area without the permission of the HOD, because these things may interfere with traffic operations. And clause 47, which is called structures other than service infrastructure in reserves or building lines or building restriction areas. I'll first just deal with what's excluded here, and that is service infrastructure, because that's talked about in Chapter 11, which you come into. Service infrastructure consists of cables, pipes, and conduits installed by another entity or person in the road or in the transport infrastructure. Whereas this section 47 deals with structures, which are things like buildings or sign supports. So structures under 47 prohibits the erection of structures that prohibited without prior permission of the HOD. And then moving on to Chapter 11, which is about service infrastructure. And service infrastructure has got clauses 48 to 55. There's quite a lot of provisions here. I'll just highlight one or two of them. 48 is about, it says no service provider may perform service infrastructure works without the prior permission of the HOD. I just want to, I'm not going to deal with detail because I talk about it later on again. So let's just not say something here that I want to make a point about later on. For clause 49 provides for the HOD to set standards and specifications regarding service infrastructure. And 52 is an interesting one. It's about ownership and control. any person other than the province who installs a conduit, pipe, tunnel, or manhole or something in the infrastructure, then relinquishes control and ownership of that infrastructure and then belongs to the province. So the conduit, once installed, then falls to the ownership of the province who owns the infrastructure or the road, the transport infrastructure. Clause 53 applies, provides for compensation. This says that compensation can be or must be paid by a service provider to the province in proportion to the disadvantage suffered by the province when this service infrastructure is installed. For example, the province may in future have to shift the infrastructure when to allow for future road widening or something like that. The department has a record has had a lot of problems in the past with electrical and communication cables and road reserves, and I think it's important to say that that legislation allows some private service providers and other authorities under national legislation to install this service infrastructure. And so the road authority can't really stop it happening, but all they can do is regulate the way in which it's done. So now we move on to the last chapter, 12. It goes from clause 56 to 74. There's a lot of clauses, and I suppose one would normally think of these as sort of legal technical clauses. But I think it is important to mention what's in there. Clause 57 provides for enforcement provisions. So these provisions may be applied by the minister if a person contravenes a provision of the bill. If you read clause 57, you'll find that there's one part of it that provides for offences. So it defines when somebody contravenes a provision, there's an offence triggered, and that then can lead to prosecution and penalties. And there's also a part of clause 57 that provides for administrative penalties. So this is an instrument that allows the minister to impose an administrative penalty on the transgressor, and this matter then doesn't go to court. It gets settled between the transgressor and the ministry, and it's quite useful because it can prevent legal cases from dragging on and on. Both of these can be applied simultaneously, by the way, so you don't have to go for one or the other. 58, the part of 58, specific powers of the head of department, it gives the HOD some powers, including the granting of financial assistance or other assistance to a municipality. Now you might wonder why that's there, because the department is already providing subsidy to municipalities under earlier clauses. We covered it earlier on, but those clauses earlier on, read with the regulations, are quite narrow in how these subsidies are paid across to municipalities. So if there's going to be additional payment made, because, for example, under the regulations, the municipality can only get 80% of the cost of the project as subsidy, and it is deemed by the head of department that in a special case, perhaps they should get 90%, then that extra 10% could be paid under this clause 58 as a grant, as additional financial assistance. That's an example. So it gives the HOD quite wide discretionary powers to make additional grants necessary. Regulations under clause 60 empowers the minister to make regulations. Now, when making these regulations, the department will follow normal practice. In other words, advertise for public comment and run a consultation process to make sure that before the regulations are made, that they're properly aired and comments are received and processed. There's no specific provision included in this bill that gives parliamentary control over making the regulations, because they're technical in nature, and it would be more efficient for the minister to have the freedom to proceed with them rather than having to take it through the legislature. But you may wish to debate this matter and take it further if it's felt necessary. Clause 61 is on standard specifications and guidelines. It empowers the HAD to set these standard specification guidelines, and they've got to be applied to transport infrastructure and roads of joint significance. Municipalities can use their own if these meet the minimum requirements. Clause 63 is about agreements related to transport infrastructure functions, and these allow the minister and the HAD to conclude agreements with municipalities and other authorities with respective undertaking functions. So, in other words, there could be an agency agreement whereby the head of department agrees with a municipality for that municipality to look after a section of the provincial road, or something like that. Clause 64, this is provides for agreements to share costs in respect of transport infrastructure. Here, the HAD can enter into an agreement with private landowners or other entities, and then these landowners or entities will contribute towards the cost of construction, upgrading, or maintenance. This is particularly relevant to the lower order roads, where very often in farming areas, the province doesn't have the wherewithal or the budget to be able to upgrade some of those farm to market roads. And this mechanism is available for landowners to come forth and offer to cover some of the costs. 65, clause 65, provides for integrated procedures and decisions. And this is where approvals are required in terms of other legislation. So it's quite an important clause, because it's meant to try and streamline or provide mechanisms for streamlining approvals that must be dealt with by a number of different authorities responding to an application. 68 is on offences and penalties for the controversial. I covered that already, I think. 69 deals with appeals. This is appeals against a decision by the head of department or an official. So the person may appeal in terms of this clause. There are also regulations that back it up or supplemented. So if a person is affected by a decision of the HAD or an official, they can appeal to the minister. This doesn't allow for an appeal when the minister's made a decision. So the recourse for that one would be to then take it to litigation against the department. 70, clause 70, is called exemptions in respect of roads of joint significance. And here the minister may exempt persons, including municipalities, from the requirements of any provision of the bill in relation to roads of joint significance. Here, for example, under advertising, it may be that a municipality has the capacity and the ability to be able to consider and approve applications, and that the head of department has full confidence and may then delegate to that. May exempt that municipality from having to apply to the minister. There's another way of doing it under clause 62, which is on delegations. That these can be made to capable municipalities as another mechanism. 72, which is the relation of Act to other laws, says that the provisions of this bill are additional to and not in substitution of other laws, which deals with matters with matters dealt with by the bill. So there may be other laws that may have to be complied with as well. For example, somebody applying for a land use change or something, it obviously must comply with the land use bylaws of that municipality and at the same time comply with this bill. 73, the repeat of the laws. Well, we know it's going to be the advertising of the ordinance and the Advertising Roads Urban Development Act. And clause 4 is the short title and commencement. It does say there that different sections of the different chapters or different sections of the bill could be brought into operation at different times. But quite honestly, it would be much better if the whole act just commenced at the same time and the same with the regulations. So that takes me through the detail. Carl, if you can just advance us on to the next slide, which I think is that one, yeah. Some of this has been dealt with before, but I just want to reinforce a few points, which we've called significant principles. The last part of this presentation is a summary of some of the significant new provisions of the bill compared to the ordinance. Let's just run through. First of all, roads of joint significance. I just want to repeat again, they're high order roads of provincial significance, which have a classification that fits into a grey zone. They're both municipal significance, which have the function of municipal road under the Constitution, and also provincial significance, which falls under the provincial function of provincial roads and traffic. And that is why they are of provincial importance, and that is why the bill then allows the province to regulate them. What they are is they're owned by the municipality, subsidized by the province. They were previously called municipal main roads, which were declared under the ordinance. When the act commences, they become RJSs, and additional roads can be declared as RJSs by the minister. Municipal main roads, which become RJSs, at the moment they are pretty well confined to urbanized areas, but there's no reason at all to declare RJSs in non-urban areas. It may be that one should extend the RJS to a few kilometers outside an urban area, so this is all now possible. The implications of these roads of joint significance. First of all, the municipality as the road owner is responsible to do all the upkeep and maintenance on it. But in the second bullet there, they've got to obtain approval for the activities that they must undertake before they do them, like construction or approval of accesses or the construction of new intersections or advertising permissions. Next slide, Carl, if we can go to this one. Just on the joint assessment process, I think I covered it fairly comprehensively early on, but it involves the department and each municipality to assess the declared road system. So all of the 32,000 kilometers and the 1,000 RJSs to be assessed. I just want to note, I think, that the province actually inherited divisional and minor roads where the divisional councils were abolished in the 1980s. Before that, the divisional councils, who were rural authorities, were the owner of these divisional and minor roads, very much with the financial involvement of the province. But they were local authorities, and so what we in effect have is quite a substantial length of roads that are technically, more than technically, provincially owned, but are local in nature, in that they serve local purposes. So that is, I think, quite a key issue. The joint assessment process may result in the agreement to transfer roads in both directions. And of course, categories of sections of roads, of the roads, may also be upgraded, downgraded. And in other words, you may find in the joint assessment process that that there's a divisional road that's carrying so much traffic and of such an important role now that it should be upgraded to a main road, you know, and jump categories that way. It's a very long time since they were actually categorized. Next slide. And then just to review the service infrastructure issues. Due to several pieces of national legislation, various authorities and private service providers have the right to install service infrastructure in land, including roads, and roads are very often convenient corridors in which to lay these cables and pipes and so on. The one that's most important today, although the same issue arises through the Telecom Act, for example, in the old ESCOM Act, where those authorities had the right just to move in and just put pipes and cables into your road. So, but the Electronic Communications Act of 2005 is really the one that's come to the fore, because it gives the power. It gives powers to the service providers, which are private companies, who are authorized by the minister of that act to install communications infrastructure such as fiber optic cables. So it's very important that this happens within the standards and guidelines, practices of the road authority. So Chapter 11 regulates the installation by service providers, but it cannot prevent them from doing so. It just regulates how they do it. And they must all comply with this regulatory requirement. Next slide. So I've really come to the end of taking you through the legislation. And I want to just cover the last couple of slides. This first one is about the regulations. We mentioned before that they were first published as a draft in 2017 with the amendment bill of that same date, and they've been updated now, and they're almost complete and ready for taking to the next step. There's quite a lot of discussion still to happen between the department, legal services, before there's going to be a landing on the final draft regulations, but they will then be advertised for public comment and consultations held, and comments will be fielded and the necessary amendments made before they are actually made to regulations. We think it's advisable and in fact necessary for the regulations to be made when they can only be made after the act commences, obviously, but that the act and the regulation should commence simultaneously, and both should commence in full. Next slide. Just a word about standard draft bylaws. The department in the process of drafting these. First, on the background, most of the municipalities actually have municipal road bylaws, and they're quite detailed. In the period of 2004 to 2010, the Provincial Department of Local Government assisted the municipalities, and most of them have these road bylaws in place. They do vary from place to place. Some municipalities also have advertising bylaws, some better than others. And so in order to fill the gaps that are there, through SALGA, the department has been requested by the municipal sphere to assist with standard draft bylaws. And once they are published, which is a process in itself, they will be available and valuable for additional provisions to be made to supplement existing bylaws. Looking at the first bullet there is a need for synchronization of practice through all municipalities in the province. That would be desirable if the way in which advertising, for example, is dealt with in one municipality should be more or less the same as the other municipality, and so on. In the second bullet there, I refer to two sets of standard draft bylaws. The one is bylaws on municipal roads, and the other is standard draft bylaws on billboards and display of advertising in public places. So it's not as if that there's a complete void in the municipalities, but there's these sets of standard draft bylaws will certainly be of great assistance. And then, obviously, there's a whole consultation process to take place with the municipalities on the content of these standard draft bylaws and the process. And the municipalities will be assisted by the province and also by the Provincial Department of Local Government in this process. Next slide. This one deals with personnel implications. And whilst the bill is different, the functions that will be required of provincial staff, posts within the department, will not really require additional staff or components to be put into place. So there's no additional staff or personnel requirements required. The second bullet there effectively says that the functions are similar to the ordinance and the Advertising Act, which it currently administers. And in the last slide, on implications, financial implications, there are some new processes, and these will have some financial implications. But in bullet 2, we say these are likely to be minimal in relation to the departmental budget. The third bullet lists, some of these processes, like the sub-bullet there, the administering of roads of joint significance, will put some additional burden. But departments are already doing it. But as you will recognise from clause 10, that there's quite a bit more detail in this administration process. Also, the undertaking of the joint assessment process, as it rolls out throughout the province, whilst it's a one-off, it's quite a substantial exercise for the department to undertake. And then the last point is this list and database, giving all the dope and information on the road system and statistics and so on. That at the moment there is a lack of cohesiveness and comprehensiveness, which needs to be seen to. So these are some of the things which may give rise to some modest costs implications. Mr. Chairman, I've got to the end of it now, and thank you very much for your patience. I know it's a very long presentation, but it's a very complicated bill, and I think that let's hand it over to, I don't know, if hand it over to you, Carl, or back to the chairman.
Thank you, Tani. Thanks, Chair, also for indulging us and the committee members and guests. Chair, if there are any points of discussion, I'll probably hand over to you at this stage for facilitating that, perhaps.
Thank you. I'll take it forward from here onwards. Members, before I give any input from my side, is there any questions? While the members go through their notes, can I just make some initial comments on my side, my page 2? If we can just look at a way, because public hearings generally going forward from our side are attended by people from different spheres of lives, obviously, in this province. And if we can find a way from the department side, particularly the second part of that bill is quite technical. If we can find a way to simplify it so that when we do the presentation in public hearings, that people can understand it easily. But from a process, from an input perspective from the department, I just wanted to get an understanding, what process did the department, and not from what we are doing as Parliament, but from the department did, and I gather also from your colleague, Mr. Abraham, I think, who's external, to get partnerships or to get input into this bill. Like I said, I did see the input from Drakensberg and the City of Cape Town, which will send on to you. What process did you follow to get input from municipalities into the bill? And then I see Honourable America and Van Westhuizen, in that order.
Thank you, Chair. Chair, I must admit, Chair, that I haven't really gone through the documentation in much detail because I only received it yesterday, and due to many other preparations I had to do, I did not give it as much attention as I would have liked to. And you've anticipated my question, but I wanted to know what was the nature of the engagement with municipalities with regard to this particular bill? Because reference is made to engagement with local as well as district municipalities. And secondly, Chair, I welcome the extension of the definition of the joint significant roads, because in my constituency, I can immediately see a road of significance in that regard, because it's a kilometer on the R62 that is being given a different name, Tennant Road. That's the sole responsibility of the municipality. That, to my mind, we didn't classify as a road of joint significance. But thank you, Chair, and I think as we go forward, and certainly then we'll be further engagement. Thank you.
Thank you. Honourable van der Westhuizen, then Honourable Herron. I think your hand was up.
Yes, thank you, Chair. Thank you very much for this and for the presentation. I must say I appreciate the fact that, you know, this proposed bill recalls a number of pieces of legislation, some of which are extremely old. And I fully agree that, you know, it's nice and I think to the benefit of all if legislation can be combined and if we don't have amendments on amendments on amendments. Chair, there are unfortunately a few items in this bill that is of concern to me. The first one is I believe that the definition of advertising is just far too wide. You know, if we scroll to the definition of advertising, advertising includes, well, let's call it lettering, but that then is intended to transfer information, having the effect of transferring information or drawing attention to something. Now, Chair, if, in my mind, each farm name sign is intended to transfer information. Each rural school that has got its name next to that road will therefore be transferring the school's name as information to people passing by. I'm talking about shop fronts, farm stalls, and to say that, you know, it can only be permitted once you've applied for such a permission. I think really it will be putting the majority of entrepreneurs in the Western Cape on the wrong side of the law if this bill is adopted in its current format. And what is also, I find, lacking is the fact that there's not even a transitional arrangement, which would say that, you know, you've got 10 years to apply, or 5 years or 3 years for such permission. On the other hand, what I find as an omission in this is that there's no reference that I could find of, for example, floodlights. And driving at night, I do experience that in many cases people are now concerned obviously about security. They put floodlights at their farm gates and other entrances, and they even try to lit the whole perimeter of their farms, and therefore those lights are often not shining downwards, but are often shining in the direction of oncoming traffic, which completely blinds on oncoming motorists. And I think if we want to improve road safety, that for me is an even greater evil than signage advertising that is there to inform the public So please, can we please have a comment on that one? Also, Chair, the distance that must be held, even if the signage is not even visible from the road, you know, hundreds of meters of farmland on which no sites can be permitted without applying for permission. Why should I apply for permission to put a sign next to a building if that building is not even visible from the road? And even if I think there could be an inclusion of saying any vehicle with a height less than 4 meters, you know, if it's not visible from such a height, that obviously then shouldn't require an application for exemption to be allowed. Then, Chair, there are some very interesting clauses. If I can take you to clause 411 and 412.
On the presentation or on the actual bill? If you can just give clarity, please.
On the actual bill.
On the actual bill, okay, thanks.
Clauses 411 and 412 on the actual bill, Chair. These are clauses that, you know, I just don't. I fail to see the need for such a clause. You know, let me just quickly scroll to. I've said 411. Sorry, I'm with 14 now. A clause which says, subject to this act. No, sorry, it's not 4. Let me go back and check my notes again. My apologies. Then 19.1, where it deals with, it seems to me, the database of all transport infrastructure. Now, it seems to me that the definition of all transport infrastructure limits to a large extent as to provincial transport infrastructure. So my first question is, why does the definition exclude roads of joint significance? And then I'm just wondering whether while we're busy with the bill, should this not refer to possible future airfields or other means of transport? Because transport is not limited in my book just to roads and railway lines. And while this bill is called the Transport Infrastructure Bill. Then, Chair, I also seem to be missing clauses dealing with the responsible entity for the maintenance of roads, road reserves, particularly in cases of roads of joint significance. And here I'm talking about, you know, the right of municipalities to be planting trees next to such roads, or to be sweeping the roads. I still recall many years ago when I used to be a councillor, and I asked the official in charge of parks, etc., to accompany me, and I showed him some serious cases where weeds have been doing damage to certain roads here in Stellenbosch, and where this official said to me, no, but this is a provincial road, you know, and then he was referring to the lower part of Elshoogteweg, those of you that know it, which is a relatively new double carriage way. And I want to avoid this issue where, you know, the municipality would be saying this is the responsibility of province, and province would be saying, no, this is the responsibility of the municipality. And in the end, you know, it gets neglected. So is there a reference to that? Because I believe there should be one, and there should be a compulsory agreement between the various role players, so that we don't find that you know, no one wants to accept responsibility for certain aspects. And then, Chair, just lastly for now, are there any clauses in this bill that will strengthen the department's case to remove illegally erected informal structures that may be putting road users at risk? I've noticed in some of our other provinces that there's a tendency to, it seems to me, almost prefer to put up informal structures in road reserves. And obviously, you know, with children, the animals, pedestrians, everybody using the road then as their main means of transport, I have found that it posed a significant risk to everybody involved. And I believe it's something that we, in this province, if we need legislation or if legislation will help us in this regard, that it's something to be considered, to be included. Thank you, Chair.
Thank you very much. I thought I saw Honourable Heron's name, but it's not. But I will just continue on 2 points that okay, Honourable Henning.
Sorry, Chair, it was.
Yeah, continue.
I was kicked out of the meeting.
Okay, sorry.
Yes, Chair, thank you, and thank you for the presentation. I have quite a few questions, I think, but let me make an overall comment that I'm concerned that we are introducing a lot of unnecessary red tape, and that I thought this was a government that was committed to reducing red tape. There is a lot of unnecessary legislation within this bill, and I share Honourable Hendrikus van der Westhuizen's concerns around some of the clauses that seem completely unnecessary, already covered in other legislation. And so I'm really concerned that this is going to tie us up in knots as we try and maintain and build transport infrastructure. I'm also concerned that there's no reference, if we want to regulate the transport infrastructure, there seems to be no reference at all to non-motorized transport infrastructure. And that must certainly form part of any bill that deals with infrastructure, because walking is the major mode for a large proportion of residents across the province, and especially low-income residents. So where is the non-motorized transport regulation and standards and conditions for those poorer residents who have no choice but to walk because they can't afford any other mode of transport? I'm interested in this idea that we can declare a freight rail system and why that has been included. And then I want to just understand some of the sections, the transport an authority of local government. If you look at the NLTA, transport planning is very much in their mandate, and there are structures that the NLTA requires to be established so that local governments are engaging with provincial governments. The classification of ancillary transport infrastructure is also a concern to me. It's quite a wide range of infrastructure that can get classified as transport infrastructure, and then that would have an impact, if I understand the bill correctly, on Section 39, which is again where the department is now encroaching on local government's role as the custodian of land use. So if Section 39 of the bill has restrictions on land use changes, requiring the HOD or the department or the minister's permission to make land use changes within proximity of transport infrastructure, and Section 16 gives creates this long list of potentially categorized buildings and depots and structures as transport infrastructure. I think this is going to create a huge problem in terms of changing urban forms so that they are more efficient, because you're going to have need permission rather than what is currently the position, which is comment from the province on land use changes. So I think in Section 39, this bill is trying to take over the functions of local government, where currently the province and the provincial roads engineers only comment on land use changes. Now you seem to want to take that role away, and any land use change will require permission. I'm also concerned around Section 46 about trading. We know a lot of informal trading exists within road reserves. and the definition is very, very wide. Again, the transport infrastructure definition is wide if we include section 16, and I think that this is going to result in the displacement of a lot of trading that is the life support of many poor communities. Section 63, again, agreements between the department and municipalities and other structures of state. I don't know why that section is required. Is there something preventing the department from entering agreements? I would like to take the department back to 2014 when Robin Carlyle was the MEC. Shortly before he retired, we concluded agreements between the province, the City of Cape Town and Golden Arrow for the devolution of the Golden Arrow bus service to the City of Cape Town. There was no requirement for a section to allow it. And as far as I know, that agreement has never has been enforced, but I'm raising it as an example of where there was a tripartite agreement without a section 63, which now creates a regulation of those, how those agreements come about. Section 65, I think, is a duplication of the National Land Transport Act, and again encroaches on local government's authority. The National Land Transport Act provides for the establishment of things like LTAB and IPCs, and so why is the province now also duplicating national land transport legislation? Thanks very much, Chair.
Thank you very much. That's the last question from the member, so I can just give some of my comments. I'm just going to ask some practical questions, please, if you don't mind, and this is to the HOD and to Mr. October and to Mr. Abrams. What can we currently not do? And if you look at the land use, I'm not going to go to each page. If you look at the R300, let's take the R300 Jakes Gerwel, for example, the sports field, not a sports field currently, and Honorable Andrika said something that triggered that question in me. That land belongs, the immediate roads, obviously the road reserves belong to the province. Will this infrastructure bill allow the, and I saw, I think on a section 7 or 8, the erecting of fences, the province now to start erecting fences on that land to avoid people for invading that land, so that land doesn't become a risk for the City of Cape Town? Or will this infrastructure bill assist this province easily in transferring that land to the City of Cape Town to do what they need to do? I'm also trying to understand what certain portions of this bill is trying to achieve. The second question would be land of roads of significance. I think there's one practical example somewhere near Grabouw, let's call it X Road, where a piece of road or servitude does not belong to the city or the province, but to national government. Will this infrastructure bill assist the province in expropriating that piece of land because you deem it as a land as a road of significance? The third question would be, if we look at the N2, the N1, and the bridges over that, and the land next to that, particularly the N2 near the airport side, how will this piece of infrastructure built, although that road is a national road, but because it's a road of significance, and we've seen at times of past times, not so recent times, of cows walking over the N2, how will this assist the province in maintaining the field or the fences next to that road? I'm trying to get an understanding the practical side of what we need to achieve in this bill. And the fourth question would be the consultation with SENRAL, because SENRAL is obviously a very key player in this as a national road agency. Has there been input from SENRAL? Has there been discussion around it as to ensure there is no duplications or functions or control over some of these issues? Has that been discussed? And then my last question or input would be around the subsidy issue, because it has been raised by the City of Cape Town, and also by the Drakenstein municipality, because they're saying that it's very subjective. You know, there must be objective criteria. Some of the comments from the city, there must be objective criteria as to how the subsidy process will work. That'll be my input into this. Honourable van der Westhuizen, I see your hand is up again.
Yes, thank you, Chair.
Okay, you can go. Last point from you, then the department can respond.
I now found the paragraph 411 and that I thought was a bit superfluous. If I can read to you 411, the provincial minister may raise and remove materials or land owned by an organ of state, but only in terms of an agreement with that organ of state and subject to the NEMA and other applicable law. My question is just, why do we need a clause like this? The same with the next one. Land vested in the province and no longer required for any purpose related to transport infrastructure may be disposed of by the provincial minister in accordance with the law applicable to the disposal of provincial state land. Again, isn't that stating, I almost want to say, something which is already there? We don't need a bill to give the provincial minister the right to enter into an agreement with any organ of state or to sell provincial assets or provincial land. Do we need extra clauses for that? If I could just get the motivation for that. And then, Chair, sorry, just to go back to the visibility of advertising signs, I do see that the word visible is used there as part of the requirements, but then there's no definition for visible. I mean, if I look from my home, I can see, infrastructure on the top of some of the surrounding mountains. So it's visible, but it will really not affect anybody. So please, if we could hear a little bit more, why was that those clauses dealing with advertising not phrased a little bit more, with care, to provide and not to make so many people, finding themselves on the wrong side of the law. You've referred to the R300, Chair. There are lots and lots of signs of buildings and so on next to the R300, which I presume would be one of the roads covered by this bill. Thank you.
Okay, thank you. HOD, Mr. October, and the rest of the team. Mr. Anthony, you can continue.
Chair, if I may start, thank you very much, and thank you to you and to the members for your comments and your questions. I've tried to make sure that I write down. There may be a few, Chair, that we miss, and or if I may request that we're able to perhaps also provide you with some either written input or an opportunity to come back on some of the aspects which perhaps you are flagging if the team are not able to respond straight away. And I must apologize that my camera is not on. I've had to transfer the meeting onto my phone because I've had a problem in the office in terms of connectivity. So with your indulgence, Chair, I'm going to then ask if Mr. October and Mr. Abramson would be able to try to respond to a number of the questions that have been raised. But before they do, I would like to just say your request to simplify the bill, certainly before we go into your public consultation process, certainly I will ask the team to do so and to engage with our DGPW communication colleagues, and we will attempt it. Engineers are not necessarily the best, and I put myself in the category of being able to simplify all of its terms, but we will do what we can. Then I do think there were a number of questions that were asked about kind of the process to this point and the interactions with the municipalities. You asked also about questions around Sunwell and others. So I'd like to request if Carl could pick up on that as
you
a
are cutting
collective.
off.
There were some
trying to get to a
points
better
raised in the presentation.
HOD Gooch.
Can you hear me now, Chair?
We can hear you now. If you don't mind getting
Yes,
to a
Chair.
better space in your office where you can get a clearer signal.
I will try, Chair. Can you hear me now?
Yes, I can hear you now, yes.
Thank you. So I'll ask Mr. October if he can try to clarify the consultation processes and so on that we went through, and then to pick up on the points, some of the elements within the bill, particularly the aspects around the advertising and others, and we'll see what we can cover generally, and then I'll step in and try and make sure I have a better line. Thank you. If I could hand over to Carl October. Thank you.
Thank you, HRD. Thank you, Chair, and thank you to all the delegates for all the questions. They're really welcome. If I could start perhaps with the consultation process, there was a slide indicating that there was vast consultations with municipalities. All of them were invited throughout the Western Cape. SALGA also facilitated some of that at the DM, the district municipality level, and so there were these engagements with municipalities and specific number of departments within province as well. There were one or two private consulting companies that also gave us comments, not on a specific bilateral with them, but they provided quite a bit of comments. I've got my team with me. I don't recall any one-on-one or engagement with SANRAL, the South African National Roads Agency. We didn't have an engagement specifically with him. However, there were also not comments as far as I recall, but I'd like perhaps anybody in the team to correct me on that. We do have engagements with SANRAL in a liaison fashion regularly, and there were discussions in those meetings with SANRAL alluding to issues within the bill, and so that is my comment on that. But I don't.
October, sorry to interrupt you. Can I just ask you one question? And I do apologize for interrupting you. Just to help us, because sometimes when we do get to public hearings, we do get councillors or municipalities ask us these questions. I did see that slide you're referring to on page number 8. Now, the comment on there say it's consultations facilitated by SALGA in January 2020. And I respect you've got the City of Cape Town, you had a one-on-one meeting, it says here, and then municipalities in the winelands in March 2020. So whether SALGA, did SALGA set up those meetings with the municipalities, and which municipalities was it? Because at times we go to public hearings and people do ask, but you were not in our district. Or so we need to be able to say, but there was meet, like with the City of Cape Town. I can clearly see on page 8, you say you've met with the City of Cape Town February 2020. You've met with the winelands facilitated in March 2020. So there's clear communication here. So I'm just trying to understand. So when this committee make a resolution after you departed, and we say, for example, the West Coast, and we go there and they ask me, I should be able to say, well, there was a meeting here last year or March 2020. At this particular moment, it just says with municipalities facilitated by SALGA in 2020. It's not particularly clear.
I think if I could just come in on that, Chair, it was done online. Firstly, these facilitated engagements because of COVID. It was around April last year. So all municipalities were invited. I remember the first engagement with DMs was we asked SALGA to facilitate that specifically for us on our behalf. We had meetings with SALGA prior to that. In the second consultation with all municipalities, the province invited SALGA together with those municipalities to an online presentation of the draft bill and discussions, which was followed by a commenting and response table, which dealt with amendments to that draft bill. The comment and response tables are all available for anyone wanting to have a copy of that. Chair, I hope that is clear. In terms of timelines, of course, the commenting period was advertised over 30 days. It was slightly extended during the COVID. And yes, and then engagements followed that. I could perhaps ask Amanda, who also provided us with legal adjudication on this, if she would want to say something.
Thank you, Carl. Yes, I recall that at the meeting with Solga, the request was for further engagement specifically with municipalities, and we advised that there should be a further round of consultation and a more intensive targeted one, and that's when the MS team meeting was arranged and all municipalities invited, as well as specifically with the City of Cape Town. And we also presented at the Department of Local Government biannual engagement. So that is particularly important, the engagement with municipalities, because of the effect of the bill on the municipalities. Thank you.
Thanks, Amanda.
Carl, may I just maybe fill in a bit of historical detail, if that's helpful? I think what Carl's focused on in the earlier part of the presentation on the slide you're looking at is the most recent round of consultations that were undertaken for the draft bill. In other words, the bill of 2021. Those certainly, all municipalities were given the opportunity, and there was that one meeting on the February 2020. With all municipalities at about the same time, where all municipalities were invited to join up in a Teams meeting to discuss the bill. So, yeah, I think in the latest round, the department certainly tried its level best to make sure everybody is aware and able to see versions of the bill and to comment and to get responses. But if I take you a little bit further back, there was, of course, the amendment bill of 2017, where prior to that amendment bill, there was a similar round of engagements, also facilitated very much by SALGA, and with many meetings held in their offices in Wales Street, not Wales Street, in Strand Street. Meetings with specific meetings that were held for people from municipalities to come and be part of the making of that legislation. And of course, those draft regulations were also circulated very widely at that time. And then if I take you even further back, then in advance of Act 1 of 2013, what the province did there is they actually put together a consultative committee with various local and district municipal officials who are responsible for road matters and so on, all formed part of this. And these, quarterly meetings were held with this group in order to try and determine what it was that the bill should be saying. So there's been a very long road of consultation, and it's impossible that any municipality might feel that they didn't get a chance to contribute or to air their concerns. I think that what was also done, of course, in the 2013 round is that when the bill reached the standing committee, then there was a round of public meetings that were held around the province to present the bill to whoever wanted to hear about it. So this is not really the first time that consultation has been undertaken.
Thank you for that input, Mr. Abrams. Once a bill passes or was not approved before an election, that bill passes. So that was 2013, we're now in 2021. But you can continue, Mr. October.
Thank you, Chair. There was a question also by Honourable Van der Westhuizen around advertising, Chair. If I could, we've got my colleague Skalk Carstens who deals with who has dealt with that advertising on provincial, as an impact on provincial roads. There was also an issue around floodlights on properties, etc., that are not regulated in terms of traffic safety. So maybe I could ask Skalk just to comment on the provisions around that. Please, Skalk.
Yeah, the outdoor advertising, the safety aspects of outdoor advertising really comes from the National Road Traffic Act in a way, and from the Constitution that the Road Authority must also ensure a safe environment. So that is the safety aspects around outdoor advertising. And this floodlights that can blind people, it's also a road safety aspect. So I do believe a road authority can use the Road Traffic Act and the safety. There's also a road safety manual, and aspects from that can be used to control that type of thing. It's not that it must be in the Act itself. And then in regulations and guidelines that can be drafted in terms of this this bill, through that one can also give guidelines, but the focus is mainly on the road safety aspects. So there's lots of other legislation that can also be used in the interim, and not this specific bill that must spell it out. But in terms of the bill, the regulations and guidelines can be provided for that type of thing. I don't know what else around the outdoor advertising. It is old legislation, and there are various guidelines nationally, but the problem is to actually have a mechanism to control the outdoor advertising safety implications, because the road authority, whether it's province or SANRAL, can be also held liable if they don't attend to safety aspects. So that is why there's also a provincial road authority and SANRAL implications, or their legislation was also taken into account. And this is existing powers that the road authorities had. It just had to be written into new legislation. So there's not a lot of things that's new, but the outdoor advertising aspect is something in terms of the Constitution that is considered the local authority function. But the road safety is a road authority function. So that is just why it had to be covered in this legislation, so that all authorities can work together. Thank you.
Thank you, Skalk. Chair, just to say these comments are sort of a off-the-cuff response in one sense, and obviously the team will have to go and caucus and apply our minds more thoroughly. But having said that, if we could move on to there were clauses 411, I think it was, and 19.1. It's difficult for me with sharing the screen and trying to get to the bill. If I could ask Tony just to look up those clauses in the meantime while we talk about the responsibilities for RJSs, which was another question. RJSs are actually municipal main roads by definition. So the municipality owns the road. However, because the road of joint significance has a sizable amount of provincial traffic passing through that and on that road. It has to be regulated jointly. So permissions, for example, for planting trees, as was mentioned, or for regulating spaces between accesses or installing new accesses along that road, reserve, the putting up of street lights, etc. All of that will have to go through the process of technical evaluation and permissions would have to be given for that. There obviously would be the need to improve our asset management information systems as we work jointly with municipalities in managing these roads. There was a question about illegalities like informal structures, and that is a current reality. It's quite scary actually, and Botchet's Quarry Road was mentioned. It's not only informal structures, but all types of smash and grabs and activities within the road reserve. Fencing is not the only solution, although the bill provides for all of that. The bill also provides for joint assessment with municipalities, which obviously would include then planning officials and land use departments within municipalities to come up with some joint intervention around these things. So to strengthen things like trading within the road reserve is also something that will have to be considered carefully, keeping safety and mobility aspects in issues like congestion and so on in mind. The road user takes priority when it comes to that. Other infrastructure like sidewalks, NMT, etc., are all covered under technical standards that don't have to be part of this particular piece of legislation, like the COLTO standards and geometric standards that we adhere to. I'd perhaps ask any of the team to come in on the next point, which is around red tape. Maybe if I could ask Amanda just to provide some comment on that, please.
Thanks, Carl. Yes, this is a point that was discussed in much detail during the consultation process with both DDAT and DEDP, and it's a very valid point. I think the answer is essentially that it must also be remembered that many of these provisions are in fact not new. Some are new, as was described in the presentation, in particular regarding the constitutional issues and the criteria in relation to municipal roads, RJSs and provincial roads, and sorting out who has what function based on the constitution. But many of these provisions are essentially drawn from the Roads Ordinance and the Advertising on Roads and Urban Development Act, and essentially modernized where necessary. So much of them aren't new. And the need for continuity in that regard is quite important. So essentially it's there for the officials to use. So we don't believe that there's superfluous provisions, and it was very carefully analysed in refining the legislation. It's a reason why we included the provisions for exemptions at the end of the bill and the integrated decision-making process, which we refined in close cooperation with DEDP in light of their experience in LUPA. So that's really in respect of decisions made under this bill and, for example, related decisions made under planning legislation, and where the authorities can cooperate in wearing those respective hats, they should do so. So that was carefully considered. With regard to the comment regarding unnecessary provisions, I think it was the Honourable Heron that raised that point regarding agreements. Just also to note that those provisions have been carefully drafted to make sure that they're not closed lists. And it was borne in mind, we don't want to tie the department's hands in this regard. And similarly, in clause 4, it's also a question you have to assess in each case, where the general rule is, yes, we do not duplicate legislative provisions, but sometimes for completeness and clarity, it is appropriate to do so. So for the roads is quite unique in where exactly it sits in respect of the property management regime and because of historical considerations. And there are some unique provisions in 4, which is why we've just tied it together by making sure we've referred to the fact that, yes, the default provision is that the legislation governing asset managed in the province and that regime applies, but here, this is where we've deviated. So we don't believe there's anything unnecessary there in that regard. Thank you, Cole.
Thanks, Amanda. I wonder if Tony's back with us on that, the issue, Tony, around moving of materials. If you could just come in there, please.
Just trying to find my microphone. Yeah, thank you, Carl. You know, we're jumping around quite a lot here with all these questions that came out. I'm concerned that maybe we're not going to be able to, you know, to provide proper. All of these questions that have been asked are all valid and important. So I don't want to sort of jump around, but maybe what I could do, just some of the questions that Honourable van der Westhuizen raised, I would like to then speak on some of those ones, if I may, Carl.
Yeah, yes, Tony, that's fine. I think Honourable van der Westhuizen did ask some of those questions.
Can I perhaps just provide some guidance? If Anthony going to speak to Honourable van der Westhuizen's questions, and perhaps then we to address all his questions, just so we don't miss certain questions. So between the Mr. Abrams, October, and Mrs. Gooch, if you can just decide how you're going to do it, because we're already 12 minutes past 4. And Member Heron's asked any questions so that we do cover everything.
Yeah, so Mr. Chairman, are you, what is I think the time that this meeting goes to is 5 o'clock, so there's only 45 minutes remaining.
Yeah, but we still need to do, after you discuss, we need to do resolutions, some additional work to ensure we get to those public meetings, schedule those things. So if we can try and get your answers done in the next 15 minutes, because there still needs to be follow-up questions, and those that cannot be answered now, we will submit written questions or for written responses. Thank you.
Okay, I think I saw Ms. Gooch's hand up there. Can I hand over to her?
Thank you.
Chair, perhaps my apologies. Hopefully the connection has improved and is a bit more stable. I would like to follow your advice. And colleagues, I've been trying to give some sense to the questions and the directions that have been asked. So let's deal first of all with Honourable van der Westhuizen's questions regarding the definition of advertising, his concern that it is too wide. If you could try to respond to that particular aspect, please, Tony. There was also a point made around distance. So in reading the definition, it gives an inference that you could be hundreds of meters away, I think was the phrase that Honourable van der Westhuizen used. And then there was also a question that he asked about why we've not included concepts like airfields and so on within the definition of provincial infrastructure, provincial transport infrastructure. So if that could be responded to, as well as then the final point that hasn't been picked up yet, that he asked around the aspects of maintenance and the responsibilities of the municipalities or whoever to do the necessary work. So through you, Chair, if I may be a little bit more directive to the team. So Tony, if you could please quickly, very quickly, give an initial response, and we will provide written responses or ask the chair if we can have a further session with them to pick up on any of the others. So if you could provide responses to those quickly, please.
Okay, thank you very much. So first of all, going from the top, the definition of advertising, I think the comment was very, very wide. We'll have a look at that and respond to that particular concern. There's a number of points that were mentioned over here. Mr. van der Westhuizen was talking about, people applying for a farm name or a school's name or a shop front. Must all these be applied for? The answer to that one is that, and I think the difficulty is that you haven't really seen the full suite of the legislation that is going to be administering advertising from the province's point of view, because they're in the regulations. Actually, you haven't seen a copy of the draft regulations, which is a pity, because that would certainly answer a lot of questions. And what the regulations do is they first of all define all types of signs that could exist, and then there's a huge number of these signs that are actually exempt from having to seek permission. For example, a school name or a shop front. These are signs that people who own these premises are entitled to put up and would not require application. That just, for example, farm names very often need to be applied for under the Road Traffic Act, because they are what they call these brown signs. There's a name for them. I can't remember right now. So many signs do not have to be applied for. The transitional arrangements. I think the concern was, that was the next point that came up on my list, is that there's a concern that when the Act comes into force, then people who are the owners of advertising would, what happens now? Do they take them down or what? I think in the regulations, maybe in the Act, it does say that people who have been successful in getting approval for signs are given approval for a certain time span. There are normally agreements in place, and after that time span has elapsed, they need to remove the advertising sign anyway or reapply. The legislation now coming out says that the maximum period for displaying that sign, I think, is 5 years. So there's a cut-off period for that agreement coming up. The no reference to floodlights. It's one of those things that you can't see because you don't see the regulations, but there is a lot of content in the regulations about floodlights and illumination and animation and all these kind of things that could happen are quite detailed and complete within the regulations. Distances, I think the distance between signs and road signs and so on, that's all dealt with in the regulations. Then I think there was a switch off from Mr. van der Westhuizen's questions, moved over to 411 and 412, which 411 is actually about the removal and raising of materials, and 11 and 12 was about the disposal of land. I think maybe Amanda spoke to 12. 11 is maybe questionable. It's so we'll have a look at that one for 11. Then we moved on to subsection 19.1, which is about the list and database for provincial roads and roads of joint significance. And what is, if you need to, I think the question was, why doesn't this list and database include roads of joint significance? And I just wanted to refer you, because that's an important point, and I wanted to refer you to section 19.8, which does actually address the roads of joint significance. Essentially, what happens there is that the municipalities who are responsible for their roads of joint significance have to assemble this data as required by the bill and regulations, and then submit this information to the head of department to aggregate with all of them. So the database does actually, in the end, capture all information of provincial infrastructure and also the municipal roads of joint significance. Then there's a question about why not airfields? Well, I guess the answer is that this bill is limited to dealing with transport for land transport matters, land transport infrastructure, and it was never really the intention to try and regulate the ownership and operation and so on of airfields. Although, of course, what can be provided is the access road and so on that serves the airfield. But once you're in the airfield, that's I know there are complexities about that one, because some airfields can be owned by municipalities. And then this last point that Ms. Gooch mentioned, which authority is responsible. Now that's a very important issue, especially when you get the point at which a provincial road becomes a road of joint significance. So if a provincial road is passing through a town like Robertson, it comes in as a trunk road at the one end, and then at a certain point, it transitions into becoming a road of joint significance and goes through the town as being that type of road administered by the municipality. Then on the other side, the same thing again. So it's very, very important to fix those points, and I think that's the issue that Mr. Van der Westhuizen isn't picking up, and it's a very real one. And then there needs to be a way in which these points of transition are actually defined. Then the last question that Mr. Van der Westhuizen had on my list is the informal structures which find their way into road reserves, where roads haven't yet been built. And we have, Sandold has a major problem on their road reserve for the N2 extension beyond where it currently ends, and then runs through to the Salaris Pass, because that road reserve is now cluttered, completely filled up with informal settlements. And the removal of informal settlements from road reserves is not something which this Act can really deal with. All it can really do is prohibit people putting structures up in the first place. But once they've been there and people live there for months on end, then that becomes a problem beyond which the road authority can deal. But I think that takes. I don't know if Mr. Van der Westhuizen, if I've covered all the points, but that's what I had listed on my notes. Can I hand back to you, Carl? Or is that Ms. Gooch? I think.
Yeah. Thank you, Tony. I'm going to just try and pick up the pace. We've got 7 minutes left. Through you, Chair, if you don't mind. There were then some questions posed by Honourable Member Heron, and we've already tried to respond to his concern about red tape. I think Ms. Tor gave some feedback on that, but certainly we understand and appreciate the concern. We would not be wanting to add things in unnecessarily, unless, as we've said, for completeness. Carl has already responded to the aspect around NMT and that it's taken up within the standards and the documentation, because non-motorized transport in terms of cycleways, pedestrian ways and so on are usually still within the road reserve and considered in that context. The transport planning aspects and structures to engage that, through you, Chair, Member Heron mentioned around the NLTA, and he's absolutely right, the mandate within the NLTA that provides as the transport planning authority, but certainly, of course, the province is also an authority from a provincial roads and traffic perspective, and he therefore needs to provide for planning within its context and the integration across into the municipalities, as well as then acknowledging that the NLTA does, as he mentioned, provide for certain structures to be established, and certainly within the Intermodal Planning Committee aspect, that is a municipality that establishes that if they have and are pursuing an integrated public transport network, significant passenger rail services, and then obviously the fact that they may establish an LTAB outside of the city of Cape Town. No other municipalities have established either of those particular transport planning structures, to my knowledge. And so certainly there is room to try to make sure that we're able to integrate and pull together the various planning aspects, particularly for the points that some of the questions that Member van der Westhuizen has raised. Your concern around the definitions and classifications around ancillary infrastructure as well as informal trading, I think similar to the points that were mentioned by Mr. Abramson, we will certainly take into consideration, give that some thought and provide some written feedback, Chair, on that particular point to the committee. And I think I've already taken up the aspects around the LTAB and the IPC, but I will double check the reference that you had through you, Chair, to Member Heron in terms of section 25 of the bill and your concern that there is duplication there. In some aspects, I think Ms. Tor has already mentioned why we provide for agreements to be entered into should we need so. Sometimes there are views expressed that unless something is expressly provided for in legislation, you can't do it. There are different schools of thought on it. Some people say, well, if it's not expressly stipulated and it's silent, well, then you've got room to maneuver. But more and more questions are asked, particularly of government departments in terms of audit processes around empowering provision. So in terms of what provision allowed you to do something, and what we are trying to do is just close any potential concerns around agreements to be entered into by this department. Then, Chair, you asked for some questions yourself around expropriating land, etc. And I do think the issue around that, understanding that there are potential amendments happening nationally as well to the expropriation legislation. The National Department of Public Works and Infrastructure has been doing some work on the an expropriation bill, but this bill is not aimed at just allowing us to expropriate. Certainly, again, the necessary processes would continue. Sunrail, they would continue as the relevant authority of their roads. There is no intention or intent, and I think Carl mentioned about any discussion. We've had no comments back from them, because certainly my reading and understanding of the bill, it doesn't try in any way to overstep any bounds from a national perspective, and but certainly to continue to work, which we do anyway, as you know, with Sunrail in terms of a collaborative approach as our roads link. But we can also just confirm that to you. The questions you asked, unfortunately, my connection was poor around the R300. I'm not certain whether members of the team had picked up on that particular question that you posed, Chair. Unfortunately, I apologize. I didn't hear your full question about the R300 there, so I will ask that Carl please just pick up on that one. And then I do believe, Chair, that the other points that have been raised, we will, where necessary, listen to the recording, of course, and then also provide you with some written feedback and happily come back to further discussions with the committee if that's required. So through you, Chair, if you don't mind noting your 4:30 timeline, could I just ask Carl to respond to the R300 question? Thank you, Chair.
Okay, I can also put some of my questions in writing. If you don't have it, I've got them here, so don't worry about it. But Carl, if you want to respond.
Right, Chair. Thanks, HOD. The R300 is also subject to our maintenance program on a regular basis. So although R300 north, I'm talking north of the N1, because south of the N1 it's Sunrail property, and then it becomes again provincial south of the N2 up to Robert up to Vanguard, the old Vanguard road. So our maintenance teams are protecting the road reserve, and as I said, doing grass cutting, dealing with any illegal occupants. That's very much part of our mandate. Some of these properties, however, within the proclaimed road reserve on the R300 North are still privately owned. We haven't really expropriated them yet or taken them into our ownership. So the private landowner has a responsibility there still to maintain those properties that are privately owned. There was another, I think it was to do, if I heard correct, Mr. Chair, about invasions mainly within the, excuse me for this. Sorry for that, Chair. We just had
We are all living at work at the moment, so we need to get used to it.
Yeah, my daughter is assisting. Thanks for your understanding. It was, yeah, I hope I'm covering the question there, Chair, around land invasions in the R300. And then land use changes, if I could just say a quick note on that. Yes, the LUPA, the Land Use Planning Act, does provide for municipalities to give permissions around any changes to land use, intensities, etc. However, trips are generated through intensive subdivisions and changes within land use. So one has to look at traffic generated volumes of traffic in many cases exceeding requirements, for example, for certain, like for example, where a four-way stop or an unsignalized intersection has to become signalized. And so that has an impact on traffic regulation, as well as the need for other intersection or technical interventions like medians within the intersection, lane widening, or even dedicated lanes, etc. So that's where the Act wants to address the issue around land use changes as it impacts the operations within the road reserve itself. Thank you, Chair.
Thank you very much. Before I continue, members, is there any of your questions that needs a burning answer or response from the department now? Member Heron, Member van der Westhuizen, Member America. Mine can wait. Member Heron, I see your hand first.
Thank you, Chair. I just wanted to briefly, I didn't get an answer, I don't think, on the land use, the department requiring, moving from commenting to requiring the permission for land use changes. And I have a particular concern around that because that goes directly to the heart of local government's mandate in the planning sphere, the obligations in terms of SPLUMA, and now an extra step for both the developer and the council or the local government authority to get this permission from the HOD, the minister, is concerning me. And I'll use an example. If we look at Buitengracht Street, I think in Cape Town, is a provincial road. It is a road that is probably ideal for delivering on densification and intensification. And if that road now requires the provincial government to give permission for every single development application that could come up in that road, I think that would be hugely problematic and would amount to red tape, entangling development and the city's vision for how it spatially evolves. It will tie that up in knots and possibly even undermine the city's spatial planning framework. Thank you.
Thank you. I see no other hand. HOD, can someone just respond to that, please? Thank you.
Yes, I can have a go if you like, Mr. Chairman, or Carl.
Okay, you can go.
That's a very good issue, very good point that Mr. Heron's raised here, and we've also wrestled with this one a lot, and Amanda could also perhaps come into it. But I think the essence of the question is, why add this red tape of requiring permission of the head of department when a land use application is made? Buitengracht Street is a very good example because from the point at which the Foreshore Freeway lands, it then actually becomes an RJS. It's a road of joints. It's a municipal main road, in other words, as it continues up towards Kloof Neck. And that's a good example of an RJS. And you're right about that, is that if every single land use application's got to be then require permission of the HOD, it would be incredibly tenuous to get through. So this is also maybe a good example where the province could relinquish the function to the municipality on a road like that, not to have to get a permission every time. I just wanted to add that he was saying, I think you made the point, Mr. Heron, that at the moment these land use changes do not require permission, but actually I'll just refer you to the Advertising of Roads and River Development Act, because that act does actually, within that act, deal with land use applications. So under that, at the present time, whilst that act is still alive, people still would have to apply for permission from the head of department for land use changes in rural areas, not urban areas. Actually, it doesn't apply in urban areas. Okay.
Thank you, Ms. Tor. Wanted to add something?
Yes, I just wanted to make the comment that I believe these provisions are legally sound based on the hurdles principle, the Max Sands principle. I don't need to elaborate necessarily in this forum. I think it's well known. But also just to point you to the fact that these permissions specifically states may only be based on provincial traffic and provincial transport operations, and clause 39.2, which also narrows the ambit of this approval. These permissions may only just to point you to that provision. So the permission may only be refused if the impact of the approval applied for on provincial traffic and transport operations cannot be mitigated through the imposition of conditions contemplated in A. So we drafted this clause in quite a narrow fashion, mindful of these concerns. Thank you.
Thank you, Member Heron. I see your hand went up again. I don't want to open up this whole new conversation. I just gave you a last opportunity. Do you want to make some quick input before I close this, please?
Yeah, I do, Chair, because I think it is important that we recall, or we remain mindful. First of all, I can't remember one of the official who spoke before Ms. Tor. I can't remember the name.
Mr. Abramson, yeah.
Yes, Mr. Abrams said it may be like Buitengracht Street as an example, may be one where the province would relinquish that right. But this legislation is removing the local government authority over its land use planning. And now, as some sort of gesture, you may relinquish that. So I think that's hugely problematic. I mean, municipalities, and especially larger municipalities, have clear development frameworks, visions for how their municipal areas should develop. And this clause that now allows or provides for the kind of removal of the authority to make a land use decision could undermine the spatial development framework of a city. And it may well be lawful, but is it correct? And is it the right thing to do, especially when a province is saying we are removing red tape, we want to encourage development? This is just another hurdle in the way of development and a potential hurdle in the implementation and the realization of a particular spatial vision. Thank you. Those are the last comments I wanted to make.
Thank you. Mr. Abramson or Mrs. Gooch, just want to, I'll give you 2 minutes to clarify that. Then we'll close on this because we know we're going to see you a few more times on this, because this is quite as you can hear, it's quite a very important bill and there's still issues that need to be clarified. Is there anything you want to say on this matter before I close on this? Just Chair, on the last point that Honourable Heron raised.
Yes, Chair, thank you very much. I think there's 2 elements to it. The first one, of course, as was mentioned, is that there's already a provision such as this within the kind of old order legislation, but I do also understand and acknowledge Member Heron's remark about trying to say, and with us wanting to modernize things, do we need to perhaps delete something that is currently there in order to further and improve and facilitate aspects? We are, however, therefore, as it stands, not removing something that because it already exists. If anything, yes, it is being provided for in a perhaps slightly more broader aspect, but we are also trying to create a law to enable us, and that enables us to delegate our control. In other words, providing for that understanding that we may be the controlling authority, but that it can be delegated to another sphere of government in terms of the municipality. But I take Member Heron's points, and with your indulgence, we will take it internally, have a bit of a discussion and a debate, and then provide you with some written feedback on it. Thank you so much.
Excellent. Thank you very much, and thank you and your team, Mrs. Gooch, Mr. October, Mr. Abramson, Mrs. Tor, Mr. Carstens, and anybody else that's still here from the department. We do appreciate that you came in front of us today. We will send you also some of our written feedback and input that we did receive from the City of Cape Town, including Drakenstein Municipality, and some of our questions that have not been addressed, so you don't have to listen to the whole tape again. But we do appreciate that you came through. We will see you on the road. We know that you will come to the public hearings to present this bill. As indicated, if we can put it in a much more simpler language for the men on the street so people can understand it much easier. But thank you very much for coming through. We appreciate. Before you go, sorry, I saw Mr. Maasdorp. Are you still here? So Mr.
Very much, Chair. Thank you very much.
Sorry, our Parliament legal advisor, Mr. Maasdorp, I completely almost forgot about you. Is there anything that you wanted to say on this?
Chair, no, I will not allow you to forget about me, but just on your question, I don't have anything to add. In fact, my concern at this stage is really on constitutionality and the soundness of the legal content of the bill. So far, on the face of it, there's nothing really that bothers. We're dealing really now with the policy subtexts, if you like, if I can put it as widely as that. But for now, there's nothing really that red flags on its own. I'm more also concerned in anticipation of the post-public hearing inputs and how that may or may not be factored in to address the concerns out there.
Okay.
Thank you, Chair.
Thank you, Mr. Maasdorp. Thank you for always being on standby here for us. Ms. Gooch and your team, you are excused, and you can thank you again for coming to the meeting. You will receive our written communication.
Thank you. Thank you, Chair. Much appreciated. Bye-bye.
Thank you.
Thank you. Thank you very much. Bye-bye.
Thank you. Colleagues, I'm just going to open my document just on just the process going forward. Johan, I'll send you my list of, I think I've got 4 questions that I've written down. 4 hasn't been addressed. The answers, I'll send that through to you. But colleagues, in terms of public participation going forward on the transport infrastructure bill, I would like to propose the following going forward. One is that obviously we need to place that, do some public hearings. Given the nature of this bill, I would suggest we don't do more than 4 public hearings. 1 in the Metro, East Region, Central Karoo in the West Region, unless that would be my proposal given the nature of the bill. Is there any other input from any other members of the committee? Honourable van der Westhuizen.
Yes, thank you, Chair. Chair, can I just ask, if we go out with advertisements and ask for comments, and then also ask people to indicate whether they would like to come and present to the committee, whether that would be able to, depending on the results of such a call, perhaps be able to replace some of the public hearings, or perhaps even all of them, particularly taking into account, that there are still limitations in terms of a maximum of 50 people at a specific venue, etc. And that we perhaps even offer to assist people that would like to address the committee and that may perhaps not have the electronic means to link up to a Teams meeting, etc., for them to be accommodated at municipal offices, etc. We have in the past been able to negotiate with local governments or other provincial entities very close to such people, to give them a venue from which they would be able to engage with the committee in terms of such comments. So I'm just raising that as a possibility for consideration as well.
Thank you, Member van der Westhuizen. Member van der Westhuizen, unfortunately, the public participation process does require us to go out, and electronic means does not replace the public participation process, even if one person shows up at a meeting in Vredendal. I'm not sure if you remember the Constitutional Court case of the N2 toll roads here in Cape Town, or not the N2 toll roads, but the toll roads here in Cape Town. The core of that case, and I'm sure the Honourable Heron will know very well because he was there, was the public participation process. SANRAL's failure to do public participation. And I mean, that is literally what the Constitutional Court has said. The role of Parliament is to do public participation. And the fact that they have not done it was the core of why they lost that case. So we don't want to, and the traditional courts bill, and the reason why that bill was also withdrawn was very simple reason: public participation. The ANC literally gave us a day's notice to a public hearing, and that's why they withdraw that bill. So we have to do public participation, and virtual hearings, unfortunately, does not replace public participation on any bill. Honourable van der Westhuizen.
Chair, perhaps Mr. Marstorff Advocate Marstorff can just explain to us, because I've been under the impression that in some other cases we have been considering Western Cape bills without physical public meetings. And I'm now concerned that we may have been on the wrong side and that we may not have been advised correctly in that regard.
Not any bill I was aware of, not in any bill I was aware of. We've done with the Environmental Commissioner bill, we've gone out at least 6 times. We've just this morning approved another 5 hearings, so that's not what I'm aware of, sorry. So I'm not sure which committee that they've done it, but it doesn't replace that. So I'm proposing a maximum of 4 meetings, 1 Central Karoo, 1 in the Cape Town. I would like to do 1 in Drakenstein, because Drakenstein was the only other municipality that gave input, and 1 in the West Coast, and obviously work with the programming committee in getting those on. Member America?
Now, I support you, Chairperson, in your proposal. Thank
you. And then the newspapers that we'll have to advertise in is obviously in 3 the languages. Sorry, just where's my document? It would be in Die Burger, Cape Times, and the Argus. And I don't see the Xhosa newspaper on your Johannes, because we have to advertise it in 3 languages.
Yes, Chairperson, we would normally use the City Vision, I think.
Yeah.
And then in that particular newspaper, we would put a isiXhosa advertisement in. So, Chairperson, is it then the Burger, Cape Times, City Vision, and Cape Argus? Shall we do those 4 papers?
Those are the main newspapers in Cape Town, yeah.
Yeah, okay.
And then obviously the normal duration, I think, is 10 days for, is it 10 days? Because it was already out for 30 days, am I right?
But Chair, yeah, it was published in the Provincial Gazette for 30 or for 21 days.
21 days, yeah.
And normally our adverts is about between 10 to 14 days, Chair. That's
okay. And then I saw the public outreach offices here, because what we need, this bill is quite technical, and I would like to ask the advice in perhaps to go out in advance, just to mobilize, not to mobilize a strong word, just to educate the communities on this bill so that they can give input in. Mr. Tembaletu, are you guys able to do that?
Thank you, Mr. Chair. Thank you so much. Yes, I can say that we are willing to do anything that the committee wants us to do, including that request we can, but I will liaise with the procedural officer to get the ball going. Thank you.
Thank you very much, colleagues. That will relate to everything on this bill. Members, we will see this particular presentation a few times. I will also speak to the HOD just to try and really simplify it, because some of the things, if you're not used to sitting in front of these committees, people are going to get bored in those meetings. So I will speak to Minister Mitchell also for them to simplify it. So that is on the matter of this particular bill. Sorry, an email just came through. Another email. Let me close this. And the emails are coming through. I don't know why I've muted them earlier on. Thank you. Members, when you look at the draft minutes for the 29th of July and the 10th of August, Johannes, can you put it up on the screen, please?
Will do, Chairperson.
And members, if you have any specific stakeholders you want this bill to go to, please submit names of the stakeholders so we can send them through. But as normal, this bill will go to all the municipalities, SALGA, libraries, so that people can give input to. But if there's any specific group of individuals you think that bill needs to send to, please alert us so we can send it through. If you can just make that bigger on page 1, please. Your excuse. Thank you, Mr. Tembeletu. Thank you. Page 1. Just go up, sorry. Oh, yeah, you can go down, yeah. I think it's just for 5.1.2, the maximum. Okay, yeah, 5.1.3, yeah. The lessons learned, yeah. 0.4, the report. Yeah, that was Member Andrikas's 1.6. Yeah, the provincial property report, a clear one. The movable asset management plan, yes. Yeah, that was Andrikas, that was Heron. Yep, the new clearer definition of that. Yeah, it seems like everybody's covered. Members, is there anything that we might have missed out of the resolutions? Can we have a mover and adopter for the minutes, please? Member America.
Move that we adopt, Chair.
Thank you, Member van der Westhuizen.
Support.
Thank you. And then the draft oversight report for the George visit.
Chairperson, just the...
Oh, the minutes of the 29th. Sorry, yeah.
29th, yeah.
Page 1. Page 2. Ooh. Yeah, we've done that. We got the presentation. Yeah. I've seen the memorandum, yeah. We've asked for the extortion. We'll schedule that review to the dates. Can we, okay, well, once you send it, if you can just send it a reminder to the department just to give us an update on the latest of the taxi. We did agree to that, yeah.
We'll do, Chair.
Thank you. And PRASA also went to send them a reminder. They did call for a meeting, but they haven't followed up with that yet, yeah. I saw that a meeting with the mayor the other day. Excellent. Can we have a mover and a shaker for the minutes? Member van der Westhuizen? Yeah.
Yes, I propose there are just 2 paragraphs 415, but it doesn't change anything to the contents.
Yeah.
And therefore, I would like to propose that we adopt.
Okay. Thank you. Member van der Westhuizen?
Support.
America, thank you. And then the outstanding the report from George. Member Heron and van der Westhuizen, you were at that in America. You guys were at that meeting. I was not there, so I'll take your lead on this one. Page 1. Page 2. Just increase the font there, please. Eh?
Trying to. Okay. There we go.
Thank you. Page 3. Okay, then we just need to get that resolution implemented. Member America, your hand is up.
Yeah, I propose that we accept the report and
Thank
adopt.
you. Member van der Westhuizen.
Happy to support.
Thank you. Johannes, is there anything else that the committee needs to resolve today that has not been adopted yet? Sorry, I see Johan van Meelen's hand is up.
Chair, yeah, maybe you can speak first and then I'll follow up after him.
Okay, Johan.
Thank you, Chairperson. Chairperson, I just want to say something quickly about public hearings and public participation. I didn't speak up just now because you didn't ask me.
Yeah.
So I'm not interfering with the committee's decision. The committee has decided to have public hearings, and that's all good and well. But I just want to mention that procedurally, Chairperson, in other committees, and if another committee or any committee decides that they first want to place newspaper advertisements and gauge the interest of the public, there's nothing wrong with that, Chairperson. Actually, that's sometimes a very good tool, because sometimes some legislation is very technical and you find that the public is not that much interested in it. So sometimes it makes more sense to first gauge the interest of the public and then to decide what manner of public hearings and where the public hearings may be. So I just wanted to allay the fears of if any other members thought that they've done it wrong in their committee, that I don't think that that is the case, because the Constitution says that public participation must take place, but it does not prescribe that it must be in the form of public hearings or how it must be. Thank you, Chairperson. That's all I wanted to say.
Thank you. Noted. Johannes?
Chairperson, yes, no, I think, yeah, the wording in the Constitution is facilitate, we must facilitate the public participation. Chairperson, my question is, if we advertise for comments and we receive written input on the bill, would you like the department to have a look at it and brief the committee again on those written inputs before we go out on public hearings?
What we'd like to do is, depending obviously what we do get back, because there seems to be quite a lot of answers still from members of the committee. So because the department generally go with us on the public hearings, I mean, they can brief us on the road as well, so it doesn't matter when.
Okay.
But we'll have a talk about it, because
okay.
I'm also still, to be honest, just like Member van der Westhuizen, when I received the documentation, I mean, we all have been busy on the road today and received this at short notice. We have to go through this in more detail, just to get a much clearer understanding of what is expected from this bill. Although this presentation helped tremendously, I think it's important that perhaps we do get a second bite of the cherry, but we'll talk about it at our next engagement as to how we take it going forward into the programming committee with our dates. Members, is there anything from your side? Anything else? 2 minutes to go. We're almost right on time. Thank you very much. There's nothing else, members. Then this meeting is adjourned.
Thank you,
Thank
Chair.
you, Johannes.